Today we have with us Dr. Arun Kumar, NIIT University, Rajasthan. Sir, I welcome you on behalf of my college and our Mula Education Society, Sonai. We have started this IIC in 2018, and in first year, we got 2-star rating for this IIC activities. Last year and before the last year, 2 consecutive years, our IIC is rated 4-star by Ministry of Education, Government of India, for conducting almost all the activities related to Ministry of Education, Government of India under MIC program and IIC program. So there are 3 different types of activity we are conducting. One is MIC driven, or you can say given by Minister of Education. Then IIC driven, SAFE driven activity, and some of the days which are can say under this particular IIC activity, that's like Environmental Day, Intellectual Property Right Day. So these are some of the activities we are conducting for the students, and students are getting benefited out of this. So today you're talking on intellectual property rights and IP management for startups. I think this is a very good topic for the students. How to can say convert their ideas into IP, or can see in early research also, and how IP is important for management of startups. So thank you very much for can say accepting our invitation and delivering this speech on intellectual property rights and IP management for startups. Thank you, sir.
Thank you so much, sir. Now, I'd like to call Mr. Jadhav AS to introduce today's guest speaker.
Thank you, sir. Very good morning to one and all. Respected Principal, Dr. Laure, sir, Dr. Khedkar, sir, and all the participants. I'm here to introduce today's speaker, Dr. Arun Kumar. His qualification is BSc and MBA in Finance. He have also completed 1 year full-time executive program in e-governance from IIM Indore. His experience in industry is about 30 years in the banking industry and about 8-year experience in academics as an associate professor at IIT University. He has also published 6 research papers and 1 book in banking industry and non-performing assets. I request to our speaker to enlighten our participant with his valuable knowledge. Thank you.
So, good morning to all of you, and I'm thankful to the organization and the organizer they have given me this opportunity to share my knowledge and my study because I am also a student of this topic. So let me share my knowledge, whatever knowledge I have gathered. So I am again thankful to the organization. So let me start. First explain what is intellectual property first. So for that, we have to first understand what are properties. Properties are of 2 types, tangible and intangible. Tangible properties are those properties which we can physically see, for example, car or building. But intangible properties, they have certain characteristics we cannot measure, we cannot feel them, we cannot see them. These properties are intellectual industry related properties and copyright related. Copyright related means I am writing a book. So why we should protect our IP? So IP is an asset. I have already explained. It is intangible assets and can be exploited by the owner for commercial gains. I can gain commercially because I have spent so much time, so much intellectual, so much so much money on this creation of this product or services or my logo. So I would like to protect it. So IP owner can stop others from manufacturing and selling product and services which are truly protected by IP owners. So I get protection. The other people cannot use my this product. IP owners can sell or license the IP for commercial gains. So I can sell it or their commercial gains. IP can be used for establish the goodwill and brand value in the market. So I can create my brand value and goodwill. For example, I have given you example of Apple. Apple is writing, just making their logo on their product, and it creates a goodwill because they are Apple product are giving higher value for their product. So they can fetch a good price of their product. Inventor, creator, or author of an IP can mention about the now kinds of IPR. IPRs are protected in accordance with the provisions of the corresponding legislature in a country. So this IPR is valid except for copyright. All IPR are valid within a country. Suppose I want to register my product, new product. So it will be registered in my country, India. Suppose I want to market in Bangladesh or in Nepal. So it will be again patented in that country. It will not globally. Only copyright which is applicable globally. So under the provisions of different acts, for example, the Patent Act 1970, Design Act 2000, the Trademark Act 1995, Geographical Indicator of Goods Act 1999, and Copyright Act 1957. Protection of integrated circuit layout and design. This is very interesting and important. 2000. So you are integrated this semiconductors integrated circuits. These are very important, and now in nowadays these are used in so many sensors, cars, and other equipment. So these are very useful, and 90% more than 70% of its market is these are produced in Taiwan, and there is a threat of China and Taiwan war. This can create further problems to these industries. We are facing shortage of these semiconductors. That's why government of India is focusing on creation of semiconductors in India. So kinds of IPR. Let me discuss what are these IPRs. The first is patent to protect technology. It comes under Patent Act. Trademark to protect word, sign, logos, and labels. This comes under Trademark Act, and designs to protect outer ornamental configuration, the Design Act. Then it comes geographical indicators to protect regional specific product. I have given you example of Kolhapuri chappal or Aligarh dog. So these are geographical indicators. It can be used in product and fruits and other eatables. For example, Tirupati laddu. So this is also an example of geographical indicator. Then copyright to product, library, and artistic work, the Copyright Act. All kinds of IPR are territorial rights. So these have only in a particular territory or in a country, it will be have the right, except copyright, which is I have told you this will be globally applicable. So let us discuss first patent. Patent is an exclusive monopoly right granted to an applicant patentee by the government for a limited period of practice or the inventions, manufacture, use, and sale in view of the information based on known as methods disclosed to the government with regard to invention. So government will patent this invention. We'll see what process you have followed. So the patent confers right to the patentee to exploit the patent for commercial gain and also to stop others from manufacturing and selling the patented product and process. So other people, they cannot use my patented product or they cannot produce my patented goods. So it gives me exclusive right for the maximum protection given for patent is 20 years. An invention in general means a new or idea. You can recreate an existing idea. You can redefine an invention according to Indian Patent Act means a new product or process involving an incentive steps and capable of industrial. So you can apply this idea or invention into industrial application so that you can exploit it commercially. Therefore, any product, device, machine, or composition process used for preparing a tangible product is patentable. What are the conditions that you can register your patent? It should be new and is a industrial use. It can be applied in industry for commercial exploitation. This is patent. You can see from your this rod different products, and you can register your patent. But if it is all innovation, no, it should be novel. Now, procedure for grant of a patent. How you can grant a patent? Filing a patent application along with the required documents. You have to file an application along with the documents, whatever the government authority, publication of a patent at 18 months for and filing a request for examination. So the government will examine the position by on the same idea, they will oppose your idea. Examination of the patent application based on the turn of the request of examination, then filing reply to comply with the requirement of the objection raised by the patent office. So you patent office will raise certain objection on your application. You have to file reply. If they are satisfied with your reply, the objection raised by the permission the patent application grant to the patent application and filing a post grant opposition by an interested person. So interested, if another person who is working on the same issue, they can file a post grant opposition also and grant of patent. Later on, it will be granted. Patent is granted to you. So this is the process involved for patent. Now documents required for file a patent is an application form, specification, drawings if needed to describe that. So you can make a flow chart for describe your invention and undertaking from section. This is your novel work. You have to give an undertaking, declaration of the inventorship, and documents to claim priority. In case of conventional application, that this is the my priority is there, and power of authority if the patent is filed through a patent attorney. So there are certain agent or attorney who can file this application on your behalf if you have given a power of authority. Then patent specification is two types. Provisional specification comprises mainly detailed description regarding the invention. So you can, in brief, you can describe, and complete specification comprises description and claims. Descriptions means technological section where you describe the best mode in detail which the inventor consider for practicing the invention, which technology I am using, which software I am creating. So enables other skill in the art to make and use the invention without undue experimentation. So this is readily available to user if they tied up with, they get permission from you to use this patent. Claims, legal section, key to all patents, protects legal rights of the patentee, defines the legal boundaries of the granted exclusive right, that is determines exactly what the inventor is entitled to exploit commercially and exclude others from practicing, making, using, selling, importing, profiting the sale inventors invention. So they can, so it is commercially. First inventor who holds the rightful ownership in the invention. So they suppose I want to create a new product or a new services. 10 years back, one of our students they have manufactured this drone. Countries, or they might be getting this manufacturing this inventor illegal heirs of the first and true inventor in case of demise of the true and first. So I told you we can give it, we can inherit it. So the legal person can give you permission to use your patent. Now, where to file a patent application? So patent office is in Delhi, which covers in state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, National Capital Territory of Delhi, and Union Territory of Chandigarh. Patent office of Mumbai They cover the state of Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, and Union Territories of Daman and Diu, and Dadra and Nagar Haveli. Similarly, we have Patent Office at Chennai. They cover the state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the Union Territories of Pondicherry and Lakshadweep. The eastern part is covered by the Patent Office, Kolkata, where rest of India, states of Bihar, Odisha, West Bengal, Sikkim, Assam, Meghalaya, or northeastern states, Manipur, Tripura, Nagaland, Arunachal Pradesh, and Union Territory of Andaman and Nicobar are covered in this territory. The term of the patent is 20 years, I told you. So the term of patent according to the amended Patent Act 2005 is 20 years from the date of patent, and it is renewal is every year mandatory. The patent will cease and it will be transferred to public domain. So what is public domain? So other person without your consent can use it. So if you are not renewing it, suppose you have patented your product and next year you are not renewing it. So what happened? After 6 months, government can put it into public domain. Now nobody will need your permission to use. So renewal is also very important. So if you are patenting any product or services or any technology, you have in order to file patent application. The government fee in India for filing a patent application is for individual it is 1,600, or other than individual like MSME it is 4,000, and private and public limited company it is at 8,000. Now opposition of a patent. Section 25 of the Patent Act prescribe applicants. So how the people can oppose your patent? So applicants wrongly obtained the invention. You have by theft or any other thing, you have obtained this application, this patent. Publication before priority date of parent application, prior claiming invention publicly knowing. So we cannot invent which is known publicly. Suppose we have some benefits of a fruit, we cannot patent that because public already knows about this invention. Obvious no incentive step and no invention as per the Patent Act. So if this, so you can oppose a patent or anybody can oppose it. Invention not this, so opposition of a patent, invention not described clearly and sufficiently, then government authorities can reject your patent. Undertaking under section about foreign filing, convention application not filed in 12 months, not disclose, no disclosure about source or geographical origin, and anticipation, traditional knowledge. So these are the areas where opposition can be lodged in a patent case. Revocation of a patent. A patent can be revoked at any time on the similar ground as applicable in case of opposition. The revocation application is to be filed at the Office of the Intellectual Property Appellate Board. So there is an appellate board also established by the Government of India under a provision of the amended Patent Act. So you can, if somebody else has through theft has taken your patent and he has got it patented, you can file a revocation as per the procedure. It is you have to file it with Intellectual Property Appellate Board. So Patent Cooperation Treaty, how this patent came into picture. So you might hear equalization. India has to make a treaty. We have to create an environment in the country for protection of IPR. So Patent Cooperation Treaty, this under this treaty, a treaty is signed. This is called Patent Cooperation Treaty. It is an international treaty which provides facility to an applicant of the member country to file a single patent application and designate the country in which the applicant wants to protect the invention. This is known as international phase of the patent application filed under PCT. Where can a application be filed? A PCT application can be filed by the applicant either at the National Receiving Center in his own country or at the Office of the International Bureau of this, which is placed at Geneva in France. The applicant claim the date of filing as the priority date in other countries during the national phase entry. So you can file internationally and you have but you have to priority date you have to mention in your national phase entry. What is not patentable? So what are the areas you cannot patent it? An invention contrary to well-established natural laws, for example, perpetual motion, gravitational force. So it is already nature has given us. So we cannot patent it. An invention contrary to the laws of public health and morality, for example, toxic drugs, item, drinks, etc., which are not beneficial for detrimental to the health of the people, you cannot patent. More mere discovery of scientific principle or formulation of an abstract theories or mere discovery of any living thing or non-living substance occurring in nature. So these are not patentable. So you cannot patent that this turmeric has a healing product. So it's known to the public. Our ancient generation in the ancient time, they are used obtained by mere only in aggregation of their properties of the component, no new product. So you are mixing as to get the benefit of both these products. It's not a patentable. Mere arrangement or arrangement of the known device working independently in the known manner. So if you can device simultaneously want to say I have invented, this is not a patentable thing. A method for agriculture and horticulture is also not patentable. Any methods of treatment of human beings or animals, plants and animals in whole or part, any part thereof other than microorganism, a mathematical or business method or a computer program, per se or algorithm, and dramatic music, etc. cannot be patented. A mere scheme or rule or method of performing mental act or method playing games, a presentation of technology or integrated kit, an invention relating to traditional knowledge, an invention relating to not patentable. Now, the recent development in intellectual property right in India, besides of the most recent developments in order to being progressively rapid liberalization of international trade practices and demonstrating the commitments to the WTO, World Trade Organization. I told you because of the globalization, you have to sign a lot of trade organization under the trade related intellectual property rights agreement. The intellectual property right agreement, the government of India understanding relating to all forms of IP has been amended or reissued in recent year, mainly in response to India's accession to the World Trade Organization. Here are some of the easiest development in IP legislation in India. So we can see what are the legislation India has made in this regard to bring Indian trademark laws in line with the international practices and to ensure implementation of India's commitment under TRIPS agreement. India replaced the Trade and Mercantile Marks Act 1958 with the Trademark Act 1999. Some changes under 1998 Act are as follows. Service mark for the first time made protectable through registration. So you can create your service mark. If you are a service provider, you can create your service mark. You can define your service, your logo, which can be put on your product. The definition of trademark now includes geographical, graphical representation, shapes, packagings, and combination of colors, thereby widening IPR protection. So now these different, your graphical representation, you can draw a graph, you can create a shape. So they have taken trademark law at par with international pact. So we have the period of registration to 10 years and trademark infringement or deceptively similar marks in relation to goods or an action for infringement. So what is infringement? Suppose I have patented, there is a place in near Mumbai. So they are making so many duplicate products. Ulhasnagar Sindhi Association, which is Ulhas. So they are making infringement of trademark and patented product. They are making there. So under the new law, both registered and registered trademarks can be assigned with or without the goodwill for the business. Protection to geographical indicators provided in the new act. India has enacted the Geographical Indications of the Goods Registration and Protection Act 1999. The GIG Act provides the registration and better protection of geographical indicators relating to goods to help identify the place of origin of goods, quality, reputation, and other distinctive characteristics of these goods. The GIG Act now helps in protecting unique features of the product. So you can now can geographically you can protect your products. For example, you are making Kolhapuri chappar, you are making Aligarh law, you are supplying this Tirupati laddu. So these can be protected now. Now, copyright law is also amended. The 2012 amendments in copyright law, which were made to make Indian copyright law compliant with the WIPO World Organization Treaty, technological protections measure ensure that fair use survival in the digital era by providing special fair use provision made many disabled. So modification in Indian patent law has been made in accordance with the TRIPS. This is international standard by widening the list of invention not patentable, incorporating greater rights of the patentee, reversing the burden of proof in an infringement suit on process patented and creating a uniform period for patent protection for 20 years for all categories of invention. Now it has made for 20 years. During 2014, the Indian Patent Office released guidelines pertaining to issuance of pharmaceutical patents. So now for pharmaceutical concerning drugs and allied products, these guidelines primarily incorporate features of various court decisions so as to assist the patent offices in establishing uniform standard for patent grant and examination. India, in giving effect to the provisions of the TRIPS agreement, enacted the Protection of Plant Varieties and Farmers' Right Act 2001 to provide for the establishment of an effective system for protection of the plant varieties. So we can protect our plant varieties. The 2001 Act recognizes and protects the right of farmers for their contribution made in conserving, improving, and making available plant genetic resources for the development of new plant varieties. New design law. So you can also enact design, you can patent it, your design. India enacted a separate law for protection of copyright in an industrial design. So you can put your design, you can put your logo, you can put your other sign for your product. The earlier Design Act 1911, the new law protects proprietors of novel.
Thank you, sir, for enlightening our students and touching various aspects of IP management. Now I request Dr. S.P. Khedkar, sir, to propose the vote of thanks.
Thank you very much, sir. I take this as an opportunity to express sense of gratitude on behalf of Mula Education Society and Institutions Innovation Council of Arts, Commerce and Science College, Sone. Thank you very much, sir, that you elaborated on most of the important aspects of patent and where we can register the patent and where we cannot. You elaborated on almost all important aspects. So I thank you once again. Thank you very much. On behalf of the organizing committee, I declare today's session is over. Thank you very much.